From supplementary list for judgment, item 1. Second appeal 402 of 2016 along with item 2.
These second appeals are allowed in their proceed terms.
Item 3, second appeal 127 of 2019.
This is also allowed in their proceed terms. The judgment will be uploaded by the evening.
From J list for hearing on order 41 rule 11 item 24. Second appeal 34 of 2021.
Complaint. 20 complaint. 20 complaint.
What is the point?
The suit was filed for actual declaration of plaintiff and performer as part of defendant number 3 of their right title interest on the suit property, confirmation of possession, and for perpetual injunction. Now, Lordship, my case is a very short case. In 1945, Lordship, I got a Sada deed, not Hukmnama, Sada deed, by the ancestor of the defendant.
Valued?
I'm not sure.
Valued?
90 rupees. There, some bullocks and some other paddies were given, total amounting to rupees 90. Therefore, it was not registered. Sada deed. Coupled with Exhibit 4, Lordship, that is the Chowkidari receipts. And thereafter, since 1948, we have constructed a house and remaining in possession thereof. This is our simple case. Now, only one defendant is there who had filed a SAR case, being a tribal, because that was from Sukru Munda. The Sada deed was given by Sukru Munda, being the tribal. Now, SAR case was filed in the year 2000.
By Sukru Munda?
No, by the present defendant, the heir of Sukru Munda. She is the widow of the son of Sukru Munda. In the SAR case was filed, registration was allowed. In the year 2003-4, the appeal was also dismissed, and the revision was also dismissed. It was for 60 dismissals of land. Of Khata and plot which has been implemented. Out of that portion, because I am not going to hide it, the execution was also done. In that execution, Lordship, out of 60 dismissals of land, 48 dismissals of land was restored to the defendant. Since there was house constructed there in 12 dismissals of land, therefore that was not executed because some term and condition was given in the trial court, and that is not our concern. That is still in position, and it is an admitted fact. Now, Lordship.
No, that SAR order had some terms and conditions.
No terms and conditions. Since when the person had gone for execution of the land, since the house was constructed in the vacant land, the possession was given. But on the portion where the Gharbari and house was there,
no excuse for not giving the.
It was somewhere it has come, Lordship, since it is not the matter of this thing, concern of this court. It has come that since the house was constructed, some amount of compensation was to be given by the land, the original owner of the land to the of the constructed matter which was already there before prior to 1969, and she could not pay, and therefore that was not restored. We are still in possession. Now, because of all these things, Lordship, there was a title clause, 258, Lordship, of the CAT Act, does not bar suit. Although it is a barring clause, but does not bar suit on the revenue court's judgment under section 71A of the CAT. 46 का है, 71A का बाहर नहीं। 258
कुछ आप बोल उसका आप आर्ग्यू कर ही रहे थे ना 258 I think you had argued this point on the last date
हाँ शुरुआती हुआ था
258
258 bar to certain suits, certain cases. Save and expressly provided in this act, no suit shall be entertained in any court to vary, modify, or set aside, either directly or indirectly, and decision, order, or decree of any deputy commissioner or revenue officer in any suit, application, or proceeding under Section 20, Section 32, Section 35, Section 42, Section 46, Subsection 4, Section 49, Section 50, Section 54, Section 61, and all those sections. Even the chapters, it is not covered. I have verified. Therefore, Lordship, my sole claim was that since the right title and interest and possession was required to be declared by the trial court, and as such, Lordship, it was incumbent upon the court to see whether the right title and interest prevails upon the plaintiff. That is my sole question. Now, what the trial court has done, trial court solely relying upon the judgment of the SAR courts has dismissed the suit on the first ground, and the second ground is that they have taken it as a res judicata. Since it was in a revenue court, and therefore it was a res judicata, what the appellate court has, both the courts have come to a finding.
You sought a declaration of title
Yes, that is right. Suit for declaration of plaintiffs and performed defendant number 3 for right title and interest over the suit property, confirmation of possession and perpetual injunction. I just wanted to show because my deed of 1945,
what is 46.3
45 deed,
46.3
46 deeds. But 46 deed. No transfer. Because they are tribal and non-tribal, therefore also 46 has been quoted. No transfer of contravention of subsection 1 shall be registered or shall be in any way recognized as valid by any court whenever in whatever exercise of civil, criminal or revenue jurisdiction. Now, Lordship, I just wanted to show the provision. When this section 46, although it is the case before the revenue courts was not under section 46, but still, Lordship, I wanted to show what 46 says. The deputy commissioner on its own motion or on an application can entertain or set aside any sale under section 46 within 12 weeks. And this was, my Sada deed was of 1945, and they have filed an SAR case in the year 2002 and 3. It is our consistent case, and from the appellate court judgments also, Lordship, will find what the appellate court has quoted, what they have stated in the written statement. That is running page 20, Lordship, paragraph 9. Running page 20, paragraph 9.
the appellate court's judgment
Lordship, in English it is in English.
running page 20
हाँ.
doesn't have a paragraph number
नहीं है, हो सकता है इंटरनल पेज 10 देखा है 10/20.
हाँ ये पैरा 9 बहुत लंबा पैराग्राफ है
हाँ हाँ ऊपर ये पैराग्राफ 9 contrary to pleadings वहाँ से contrary to pleading of the plaintiff appellant, the respondent defendant, what they have pleaded, that is has been quoted. Most Charagi has categorically denied the plaintiff's case in the written statement filed on behalf before the alleged trial court and has stated that although, this word is important, although Sukhu Munda has transferred 20 districts of land to Devendra Nam in the year 1945 by Sada deed, which was out and out contrary to the provision of section 46. हम इतने उसमें यहाँ दिखाना चाह रहे हैं ये नहीं डिनाई कर रहे हैं कि सादा डीड नहीं था. And when the sada deed has not been denied, then it was incumbent upon the courts to decide my right, title and interest based on the sada deed. Only brushing aside by saying that all the revenue courts have passed an order against you, and without considering the fact that it was also beyond limitation. And had there been a barring clause in section 258, I would have been out of court. Since the application was filed under section 71A, therefore the trial court and the appellate court.
You formally did not challenge the order under section 71.
चैलेंज हुआ तो कमिश्नर तक यहाँ खत्म. हमारा एक्सक्यूशन भी हो गया, बचा हुआ है. Since my pleading is for 60 dismiss.
You are only concerned with 20
now only 12 dismiss.
12 dismiss.
Although we have filed an application for 60 dismiss, but lordships have power to modify my claim. Since we are just reducing our claim, because now only that house is there standing there on. We are living there since 1948. That is only my case. As of now. And lordship, my substantial question of law is C, D and E lordship.
You are concerned with 12 dismiss.
अब तो है होगा क्योंकि execute हो गया है and it has not been challenged. Now if any finding comes, it will only come with 12 dismiss because that has admittedly not been excluded. C and D is incorrect. Sada deed is exhibit 1.
What is B? Original plaintiff and the present appellant were not party. The predecessor in interest must have been party. Isn't it? B क्या बना है?
हाँ ये उनका 71A का ये जो प्लेडिंग यहाँ लिए है WS में ये हमारे जो प्रेडिसेसर और भी हैं जो हमारे जो और भी एयर्स हैं सुप्रीम मुंडा के वो पार्टी नहीं है. तो हमारा कहना है कि we are aggrieved only by the execution which was initiated by the defendant and others have no concern with the land because their ancestors have given the land to us by sada deed and only this defendant had initiated a proceeding on section 71A and she has got it restored for 48 days. Therefore, we are concerned only with that.
So, but once we are seeking a declaration of title, were they not required to be made party? इस पर भी कोई finding नहीं आया?
इस पे कोई finding नहीं आया, but from the pleading I have taken. Finding तो सिर्फ 3 ही point पे आया कि SAR कोर्ट का है 45 का डिग्री में हाँ ये भी कहते हैं कि 45 का जो deed है that is not proper, although it has not been disputed by the defendants. And thirdly, res judicata.
आपका A, C and D होगा ना?
हाँ C and D बस C and D पे इंसान था.
और A?
हाँ ये मेन res judicata वही तो मेन है उसी पर खत्म कर A, C and D.
Hold the learned counsel for the appellant. The learned counsel for the appellant has submitted that the plaintiff was relying upon a saga deed of the year 1945, which was valued for ₹90, and therefore the same was not required to be registered. He also submits that by virtue of Exhibit 4, the Chowkidari rent receipt, it was clear that the plaintiff was throughout in possession of the property. Submits that in the year 1948, a house was constructed on the suit property. However, the sale deed was executed by Sukul Munda.
Yes,
Sukru Munda, and the legal heirs of Sukru Munda had filed one SAR case for restoration of their land. In which order was passed against the plaintiff and restoration was allowed with respect to 60 decimal of land. The order of restoration passed in the SAR case was challenged by before the first appellate court and then before the learned, and was challenged, but ultimately it attained finality. At the stage of execution, only 48 decimal of land was restored and 12 decimal was not restored, as the house of the appellant was standing on the same.
yes.
The learned counsel has submitted that the appellant would confine their relief to 12 decimal of land, which continues in their possession. He submits that Section 258 of Jharkhand Tenancy Act does not bar a suit even if SAR case is decided between the parties.
Under section 71.
Under Section 71, capital A of Jharkhand Tenancy Act. It submits that the suit was filed for declaration of title and confirmation of possession. The learned counsel submits that the learned trial court and the learned court held that the suit was barred by res judicata primarily by referring to the order passed in the SAR case under Section 71 capital A of the Jharkhand Tenancy Act. You are tribal, non-tribal.
No.
The appellant is non-tribal and admittedly the defendant was tribal. He submits that the suit was to be decided on merits and the same has been decided on technicalities, which is not as per. He has referred to substantial question of law number
AC.
A, C and D. Considering the submissions, this appeal is admitted for final hearing on the following substantial question of law. A, C and D. Page 5 में है memo of appeal. Issue notice to the respondents for which requisite under ordinary process and speed post be filed within 2 weeks from today. Office to tax speed post delivery. Raise this case
Yes, yeah.
on this one. वो list लीजिए. Yeah. Nineteenth of January, 26. That the records be called for from the consent court. Communicate the ordinary facts. ये decide नहीं हुआ अभी तक. ऐसा कैसे हो सकता है? ये 71 and suit लाई करेगा कि नहीं?
अच्छा वो पॉइंट पे नहीं डिसाइड हो गया हमने उस पॉइंट पे डिसाइड हो गया कि 71 ए जो dispute है it is generally between tribals and non-tribals and generally court sees whether 30 years has passed or not. इसमें पता नहीं कैसे नहीं हुआ अपडेट अभी तक नहीं हुआ नहीं दिखा गया वो डिनायल नहीं है चौकीदार रिसिप्ट है that is not a created document.
नहीं मतलब रेस जुडिकाटा वाला point when the suit would lie even after the order passed under section 71A has they been decided? कौन सा? परितोष स्मृति तो इस पर नहीं है। परितोष स्मृति है वो दूसरा point है। वो SPT Act लेकिन प्रिंसिपल वही है।
हाँ यस
नहीं हम तो कई केस में रेफर किए लेकिन हमको याद नहीं।
परितोष स्मृति मतलब लीडिंग
बस एडवोकेट।
और उसमें बहुत सारा चीज डिसाइड किया है कि मतलब अगर बार भी है तो भी वहां पे बार नहीं है दैट इज आल्सो
हाँ ठीक है अब मेरे पास रहेगा नहीं रहेगा हम नहीं जानते लेकिन इंटरेस्टिंग 71A के कॉन्टेक्स्ट में डिसाइड
हाँ यस my senior is correct he's correct because I have also got that through that अभी मुंह पे नहीं आ रहा था नाम
ठीक
Item 25, second appeal 38 of 2021.
The plaintiff respondent to suit the judgment of reversal.
एक सेकेंड परितोष स्मृति था डिसीजन ऑन रेक्टिफिकेशन ऑफ रिकॉर्ड ऑफ राइट्स उसमें रेक्टिफिकेशन ऑफ रिकॉर्ड ऑफ राइट्स में 3 months टाइम है एंड इफ अ पर्सन डज नॉट गो टू द रेवेन्यू कोर्ट्स then he can still challenge it after till 12 years.
Yes, ma'am.
लेकिन 71A पे नहीं है वो।
Suit can be filed.
Suit can be filed.
Bar can.
हाँ वो अवेल नहीं किया रहेगी बट हियर इज अ केस 71A में अवेल करके इविक्शन ऑर्डर हो गया
तो वो अलग
तो
वो अलग
वो उस पे
वो रेक्टिफिकेशन ऑफ रिकॉर्ड ऑफ राइट्स पर
जी जी
89
बार की पर बोल रहे हैं हम सेक्शन 258 जो बार
हाँ
उस पर
दैट इज द
प्रिंसिपल वही है 258 का
हाँ तो इसके लिए 71A के लिए तो अलग से डिसाइड करना पड़ेगा ना
हाँ
यहाँ पे कितने रिट्स हैं
उसको
71A
लेते हुए डिसाइड करना पड़ेगा
उसको लेते हुए डिसाइड करना पड़ेगा ऐसे नहीं होगा
क्योंकि 258
एंड इट हैज अ वेरी सीरियस इम्पैक्ट
यस
क्योंकि बहुत सारे में जो पोजेशन हो गया है या मान लीजिए वो लोग अपना जैसा भी करना चाह रहे हैं
जी now this is an appeal by the plaintiff who succeeded in the suit then in appeal it was reversed and lodging a suit for declaration of right title interest on the basis of the title which was acquired by virtue of the mortgage suit 5 of 1943 the vendor in execution case 9 of 1945
you are representing the vendor
no I am representing
purchaser.
the story
Okay.
the story is 1943 vendor's vendor then vendor's vendor after getting it confirmed on 15/6/1945 then he sold it to my vendor Mahavir Ram by registered sale deed dated 8th of July 1948 who came in possession then he sold it on 29th of December 1950 to Shiv Shankar Prasad by registered sale deed. Those are exhibit 7 series and ultimately it was sold on 25/7/1970 to the plaintiff by to the vendor of the plaintiff that is Akshay Kumar who sold it to the plaintiff on 11/1/91. So a series of sales not at least from 1943 and we came in possession
1943 is mortgage suit
yes that is mortgage possession confirmed and that mortgagee he sold it to Mahavir Ram sold it Mahavir Saab who sold it to Shiv Shankar Prasad and then Shiv Shankar Prasad sold it
it
to
was this property was sold out in a mortgage suit or in mortgage
execution case
in execution
in execution case
do you have the case number
yes
anyways
yes that is 9/1945 in the synopsis I have stated not this thing
okay 1945 So what is your substantial question of
Now,
law? Why the court
now
has
the
decided
learned
against?
trial court
Hmm.
found the title of the plaintiff. He also recorded in page 15, para 5C, that the suit land does not suffer from any vagueness. Then not in para 5B, the boundary of the land could be presumed to be true in absence of any
That's right.
contradictory
Everything found in your favor.
in my favor. Now the appellate court only on the one ground, that your Lordship may kindly see page 13, para 18 of the appellate court judgment. Exhibit 3 and 6 do not show description of the suit land and does not tally with the Khatian and sale certificate. A sale certificate after 4 transfers I came into possession on 11/1/91, and that is the only ground, and therefore on the basis thereof the learned appellate court found
The description of property is different.
they say it does not tally with the Khatian. Without taking into consideration the area of the land which I have purchased, area which was in the Khatian, and ultimately it said not in page para 18, plaintiff could not prove her case by documentary evidence. Now your Lordship may kindly see this is inconsistent and contradictory in nature. If your Lordship may kindly turn to appellate court judgment itself, page 16, inner page 7. Inner page 7. Page 16, running page. Para 3, the issues. Thereafter, your Lordship may kindly see page 17, witnesses. And there, in below it, your Lordship will find the documents which have been filed by the plaintiff. Exhibit
What
1.
what was the description of property in Exhibit 3 and 6? How different was it?
That is not, for that purpose, your Lordship may kindly come to the discussion part.
Exhibit 3 is the Khatian.
Khatian.
Okay.
That is the reason I was referring to page
Okay.
16.
And Exhibit 6 was sale certificate.
Yes, sale certificate. Now your Lordship may kindly see the
Just a moment. Exhibit 3 is
CC of Khatian
which Khatian?
in the name of Dayal. This
Which
is only
Khatian?
Khatian. Only Khatian, not it was
Cadastral
prepared-
survey. CS.
Yes, CS. There was no other Khatian not in Giridih.
When was the CS done?
In 1908, much prior to it. Thereafter, no RS Khatian is in Giridih district. Then Exhibit 6 is CC of Certificate of Sale of Land.
What is the description of property in Exhibit
Yes,
6?
for that purpose, the learned appellate court, what has been discussed, subject to Lordship's kind conscience, very short judgment. The Lordship may kindly come to page 21. Page 21.
Yes, I
In
know.
our page 12. Let us consider oral and documentary evidence. It starts like so. Now, Lord, on perusal of the case record, I find plaintiff have filed several documents which has been marked as exhibits. Out of the same exhibit 3 CC of Khatian in the name of Dayal Teri for plot number 838 and 839. Exhibit 6 is CC of Certificate of Sale of Land are very important documents, and both are documents are genesis of the plaintiff's case. So let us examine both the documents filed on behalf of the plaintiff. Exhibit 3 CC of Khatian is most important document upon which case of the plaintiff fully depends on perusal of Khatian. I find same is not legible. According to pleading of the plaintiff, Khatian is said to be in the name of Dayal Teri, but the same is not legible. Although it has been pointed out by the defendants that the boundary of plots are not legible and the boundary of the west and north can be read and no other document details are mentioned, and this fact has also been observed by the trial court on its judgment by what the plaintiff kept mum on this point and no reasonable explanation has been given by the plaintiff on this point. As such, the plaintiff failed to prove the above fact. Further, on perusal of Exhibit 6, 3/7/1945, I find in description of land only Thana number 288, holding number 783, ward number 3 and boundary east building of Karman Sahu, west building of Dhanu Teli, north Chaman Kumar and west road is mentioned. But in sale certificate, neither area of land nor plot number mentioned. So complete description of land has not been mentioned in sale certificate of land. Although the plaintiffs have claimed the right title and possession over the suit land on the basis of Register 3, marked as Exhibit 5, rent receipt Exhibit 2/2IA, municipal rent receipt Exhibit 1/1D, survey map Exhibit 4, and other documents which have been marked as exhibit. So from above it appears that the preferred description of
बेटा ये
the
आपका क्वेश्चन ऑफ लॉ कहाँ बना?
number lossy mechanism A, B and C. And before that, trial court judgment it has made clear. Survey map is there, plot numbers are there. My sale deed also contains this. Vendor's sale deed also contains the sale description of the property. It's A, B and C. That is at page 5. The trial court found that the plaintiff has been able to prove the suit land and its title. In para 5 at page 36, 5A and 5B.
Okay, however, the learned counsel for the appellant. The learned counsel for the appellant submits that the plaintiff claimed suit property by virtue of series of sale deeds one after another. Originally, the suit property was sold in execution case number 9 of 1945 in a mortgage suit. And a sale certificate was issued in favor of the purchaser, which was marked exhibit 6. He submits that thereafter the property was sold by registered deed on 8/7/48, followed by registered deeds dated 29/12/1950, 25/7/1970, and 11/1/1991. And the plaintiff came in possession of the property, and rent receipts were also issued in favor of the plaintiff. Rent receipt आपके favor
Yes,
में?
yes, sir.
In
Exhibit
favor
one.
of the plaintiff.
1 to 1D.
Exhibit 1 to 1.
Exhibit 2 to 2 by A, rent receipt, and exhibit 1 to 1 by D, municipal taxes.
Exhibit 1 to 1 by D are the municipal tax receipts, and exhibit 2 to 2 by A
Yes, that is
Other?
government receipt.
are the rent receipts,
Yes.
government rent receipts. The learned counsel submits that the learned trial court decreed the suit,
Holding that the plaintiff has been able to prove.
holding that the plaintiff was able to prove his right title, interest, possession as well as the identity of the property.
Yes.
But the learned first appellate court has reversed the finding by referring to exhibit 6,
3 and 6.
exhibit 3 and 6, and has not considered the other documents placed on record which were relied upon by the learned trial court to hold the finding in favor of the plaintiff. He submits that the judgment of the learned first appellate court is perverse and a substantial question of law will change. A. Whether the impugned judgment passed by the learned first appellate court is perverse on account of non-consideration of the materials placed on record, on the basis of which the learned trial court had decreed the suit. इतना हो जाएगा?
Yeah. Name of Mr. Prabhas Kumar Sinha, yes, sir.
Just a moment. एक चीज और. Materials on record में कौन सा exhibits
Exhibits
बताएं?
plot,
Exhibits,
first 7 series plot, which are the same.
exhibit 7 series,
Exhibit 1 series and 2 series.
1 series and 2
series
series.
and,
Map
one,
भी बोल
and
रहे थे।
register 3. Register 3 is
Exhibit.
exhibit.
Exhibit,
Yeah. Exhibit. Register. Yes, exhibit 5.
exhibit 5 or 4 survey map.
4 is the survey report. Yes.
Uh,
1, 2, 4.
exhibit 1 series, 2 series, 4, 5 and 7 series.
7.
जहाँ लिखे ना substantial question of law, non-consideration of materials placed on record, within bracket, exhibit 1 series, 2 series, 4, 5 and 7 series. ठीक है? Issue notice to the respondents for which requisites under
The name of Mr. Prabhas Kumar Sinha appears in the list. Most probably he appeared for some respondents. Total Krama has been filed. As per the
just a moment. One and two की तरफ से आते हैं. Issue notice to the respondents since Mr. P.C. Sinha, advocate, has already entered appearance on behalf of respond number 1 and 2. The notice is waived. ये तो हो ही गया, सारे ही appear हो गए.
सारा appear. I can take press notice because today nobody is appearing. Or I can inform you.
क्या करेंगे? ऐसा कर लीजिए. Since respond number 1 and 2 has already entered appearance through a counsel by filing wakalatnama, no notice need be issued to the respondents. Call for records from the concerned court. Let this order be communicated through fax. Office is directed to forward a soft copy of this order to Mr. Prabhas P.C. Sinha, advocate, to ensure his appearance on the next day. ठीक है?
Yes.
उनको नहीं होना होगा तो आके बताएंगे क्या करना है.
हम inform भी कर.
He was here in the first half. वो अक्सर में सरकार का भी बहुत काम करते हैं किसी और.
जी. Date will.
डेट बताइए कौन सा डेट आपको? 19 January.
19 February.
January.
January.
Item 26, second appeal 61 of 2022.
The supplement.
Well, this is plaintiff's respondent's second appeal.
Reversal.
Suit defeat. Appeal filed by defendant was allowed. Prior to advancing my argument to it, I would like to refer an order number 5. Though it cannot be termed as order of admission of second appeal.
Can you read it?
Yes.
So such and such learning senior counsel appearing on behalf of the appellant submits that the finding recorded by the trial judge that the vendor of the plaintiff had directly executed the same deed, whereas the vendor of the defendant had got no right to execute the same deed. However, the lower appellate court reversed the judgment and decree passed the title suit on the 18th of 2007, only on the ground that the same deed executed in favor of defendant was prior in time. On request of Mr. So-and-so, the learned assisting counsel to Mr. So-and-so.
This is factually correct.
It is factually correct.
Now let us see your substantial question.
Yes. whether while reversing the judgment and decree of the judge's trial court, the judge's lower appellate court acted within four corners of order 41, rule 31 of Code of Civil
Point for determination accepted. Number 2 तो काफी होगा.
that was number C determined. Apart from the
Number B should be sufficient, whether the findings of the learned court of
That is-
appeal
that
were
is sufficient.
initiated due to not meeting the
not
reasons.
meeting the reason. This is Department of Law.
Has held that all the three saldies of the plaintiffs with respect to the land was valid and legal, and those saldies have never been challenged or set aside.
From conclusion of trial court judgment was also find that there was complete partition between post errors. That is, kindly come to running page 54.
I'm just in the order dated, order number 5.
Yes.
Vendor of the plaintiff has validly executed the saldi, whereas the vendor of the defendant had no right to execute the saldi. I would the learned lower appellate court reverse the judgment in between parts and that is become a sentence of only on the ground that the saldi is executed. Where is that finding?
Yes.
आप हमको फाइंडिंग दिखाइए.
Yes.
इसी तरह से सब्सटेंशियल क्वेश्चन का प्रॉब्लम है.
Therefore, but I am referring running page 54, internal page 14 of the trial court judgment,
That's right.
where issue number 8 has been dealt with.
Yes.
Yes. थर्ड पैराग्राफ में कंटिन्यू.
हाँ, I'm there.
दोनों पक्षों को सुना, वादी के द्वारा दाखिल दस्तावेज प्रदर्श A by B एवं प्रतिवादी द्वारा दाखिल दस्तावेज प्रदर्श A के अवलोकन किया. अवलोकन से स्पष्ट होता है कि चेतन बैठा द्वारा प्लॉट नंबर 13 और 21 में के 21 डिसमिल जमीन की बिक्री किया गया है तथा प्लॉट नंबर 13 का ही 42 डिसमिल जमीन प्रतिवादी को रामचंद्र बैठा के द्वारा बिक्री किया गया है. इस संबंध में दाखिल दस्तावेज जो प्रदर्श 2 अंकित किया गया है, जो खतियानी है और वह खाता नंबर 5 से संबंधित है, जिसके अवलोकन से स्पष्ट होता है कि खाता नंबर 5 प्लॉट नंबर 13 कब्जावारी में धोधो बैठा के नाम से अंकित है और धोधो बैठा के वंशज मोती बैठा तथा चेतलाल बैठा है और मोती बैठा का पुत्र रामचंद्र उर्फ जीतन बैठा है, जो कि प्लॉट नंबर 13 की संपूर्ण जमीन 42 डिसमिल प्रतिवादी के पक्ष में विक्रय विक्रय किए हैं तथा धोधो के ही वंशज चेतलाल बैठा ने भी प्लॉट नंबर 13 के 21 डिसमिल जमीन वादी संख्या 2 के पक्ष में बिक्री किए हैं. इस संबंध में प्रतिवादी के द्वारा न्यायालय में दिए गए साक्ष्य के अवलोकन से स्पष्ट होता है कि प्रतिवादी ने अपने साक्ष्य में कहा कि कब्जावारी के अनुसार बंटवारा हो गया है. खाता नंबर 5 के अनुसार प्लॉट नंबर 13 धोधो के कब्जावारी में था तथा धोधो के वंशज मोती और चेतलाल थे और प्रतिवादी ने न्यायालय में अपने साक्ष्य में कहा है कि मोती और चेतलाल का बंटवारा हो गया है तथा मोती और चेतलाल दोनों अपने अपने जमीन में दखलदार थे. दोनों पक्षों के साक्ष्य के अवलोकन से कहीं भी स्पष्ट नहीं होता है कि प्लॉट नंबर 13 का संपूर्ण जमीन रामचंद्र के दखल कब्जा में था. ऐसी परिस्थिति में प्रतिवादी के साक्ष्य से ही प्रतीत होता है कि मोती और चेतलाल में बंटवारा हो गया था और दोनों अपने अपने हिस्से में दखलदार थे और प्लॉट नंबर 13 के मुसल्लम जमीन 42 डिसमिल है तथा मोती और चेतलाल दोनों ही उस जमीन के हिस्सेदार हैं और चेतलाल के द्वारा अपने हिस्से की ही जमीन विक्रय मेलिक संख्या 16 दिनांक 27/12/83 जो प्रदर्श 1 by B अंकित किया गया है, जिसे किसी सक्षम न्यायालय में चुनौती नहीं दी गई है, न ही उक्त विक्रय विलेख को रद्द करने के लिए किसी सक्षम न्यायालय में वाद लाया गया. ऐसी परिस्थिति में वादीगण के द्वारा दाखिल उक्त दस्तावेज वैध है जो चेतलाल बैठा के द्वारा सिर्फ अपने हिस्से के संबंध में किया गया. अतः उपरोक्त परिस्थितियों में वाद बिंदु संख्या 8 वादी के पक्ष में निर्मित.
What did the appellate court do?
Yes. He has taken issue number 8 only for consideration. And kindly come to running page 27.
Yes, I am.
Internal page 40.
Yes. And there, what is the finding?
Yes.
Findings start from page 35, Lordship.
Yes, I'm there.
Paragraph.
This
The respondents plaintiffs have claimed the title over the suit lands on the basis of sale deeds filed in the instance. In support of their contentions, they have filed sale deed number 677 dated 1, sale deed number 8191 dated 27/7/2021, and sale deed number so and so dated 27/12/1983 exhibit 190. The sale deed number 677 dated 21/1/82, which is alleged to have executed by Ramchandra Mehta alias Jitan Mehta in favor of Vishwanath Ram, respondent plaintiff number 1. The learned counsel for the appellant defendant has contended that the opposite sale deed is related to the land of plot number 35, measuring an area 23 decimals, and the said deed is illegal because of the fact that the vendor had no right to execute the same in favor of the respondent plaintiff. In fact, plot number 35, area 25 decimal, was left for the defendant in exchange because the said Moti Bata and Chetla Bata had sold the lands of Chito Bata, father of the defendant, that is, 3 plots were sold to Guru Prasad Ram, and later on, the said Guru Prasad Ram sold the same to Shada Pandey. As such,
For a moment, that I may be allowed to state that there is no case of exchange in the written statement.
later on said Guru Prasad Ram sold the same to Shada Pandey. As such, it is the reason that their Kachawari land of plot number 35, area 23 decimal, was allotted to the father of appellant defendant as in exchange. BW1 has also admitted to the extent by para 38 that after mutual understanding among Shetland, Modi and Shitu, three plots that that is joint property have been sold by Shetland and Modi in their lifetime to said Guru Prasad Ram. In this way, the appellant defendant came to peaceful possession over the aforesaid land. The respondent plaintiff does not have title possession over the aforesaid land on the basis of sale of Keys 1/1982, alleged to have been executed by Ramchandra Mehta against Jitan Mehta.
This is the sale deed alleged to have been executed by Ramchandra in favor of wife, plaintiff number 2.
Therefore, the vendor, that is Ramchandra Mehta, had no right to transfer plot 35 measuring area 0.20 acres out of total area 0.23 to the respondent plaintiff number 1. As such, it is alleged that the plaintiff had never been put in possession over the land of plot number 35, measuring an area 0.20 acres out of 0.23 acres. From the result of evidence of PW1, it appears that by para 42 he has admitted that at the time of erecting compound wall over the land, the appellant defendant Pankru Mehta, he had assaulted him, but he did not lodge any case in the concerned case. Further, PW1 has admitted that he had not filed any application before the CGM directly. PW1 has also admitted this fact that in para 44, that when the appellant defendant was erecting compound wall, they had not given any application before the SDO for restraining the boundary wall. By para 64, PW1 has further reported that in the sale deed of year 2002, neither he made witness to the heir of Chetlal Beta nor the heir of Modi Beta. Further, from the perusal of record as well as documents as available on the record, it transpires that plaintiff number 2, Premlata Devi, the wife of plaintiff number 1, had got sale deed executed from Chetlal Beta, one of the co-sharer of Ramchandra Beta with respect to land of Khata number 5, situated in Moda Salaya, measuring total area 0.32 acres in plot number 13, measuring an area 0.21 acres out of 0.42 acres. And in plot number 31, an area 11.11.
The case of the defendant was primarily based on the exchange.
No case has been made out of exchange.
No, but
Yeah.
discussion is there.
Yeah,
But
there
it
is
was-
a statement. There is a statement of some witness, but the statement of witness cannot be corroborated by written statement.
Written
Since
statement,
has
it was
not
never
been
their
plead-
case.
Since it has not been pleaded, it should not have
Certainly.
been taken note of.
There is no such case of the defendant that it was based on some kind of exchange.
Not at all. And we have proceed. Further, ultimate finding.
Huh.
Last paragraph. The property is joint and Ramchandra Beta and Chetla Beta are admitted as co-sharer of each other, out of whom Ramchandra Betta is executed said deed dated 15/3/1982 with respect to plot number 12 area 0.31 acres. The entire plot number 13 area 0.42 acres, the entire plot number 31 area 0.6 acres, and plot 40 area 7 acres out of 0.27 acres to the defendant applicant, then the said Chetlal Betta had no right to transfer 21 acres out of 0.42 acres of plot number 13 of Khata 5, and he has also no right to sell an area 0.11 and a half acres of plot 35 out of 0.23 acres on 27/12/1983. Therefore, the sale deed of the appellant defendant dated 15/3/1982 is an earlier document than the sale deed dated 27/12/1983 executed by Chetla Land. The land purchased by sale deed dated 21/1/82 pertaining to plot 35 area 20 decimals out of 23 decimals appear to be Mahua Bari comprising of Mahua tree and Cotton tree in the Khatian, marked exhibit 2, with an area 23 decimals, plot number 35 shown to have niche lands on all four sides, whereas the recital of the sale deed mention existence of Makan in the area 20.
The sale deed covers the entire Sukhland.
Yes. Trial court has specifically find that there was a complete partition and Ramchandra has got no right to sell. Now that the defendant is challenging the only sale and we have sought declaration for three sale deeds. Schedule 1, 2 and 3. Ramchandra Dhobi, alias Jitesh Dhobi sold Khata number 5, plot number 35, area 20 decimals, and plot number 56, area 59 decimals to plaintiff number 1, husband. While the registered sale deed dated 21/1/1982. The second sale deed purchased by plaintiff was plaintiff purchased land of Khata number 5, plot number 13, area 21 decimals, and plot number 35, area 11.5 decimals, in the name of his wife, Srimati Premlata Devi, plaintiff number 2. Third deed, plaintiff purchased 15 decimals of plot number 45, Khata number 5, from Chetla Dhobi, while registered sale deed. All the details of sale deeds are given in schedule 1, 2 and 3. Three sale deeds, on the basis of three sale deeds, declaration was sought for. And we were dispossessed, then we filed suit. We were dispossessed on 17/3/2007.
How?
17/3/2007.
Why were you dispossessed? How were you dispossessed?
Dispossessed by force.
By force.
And thereafter they constructed the boundary wall thereof.
The learned counsel for the appellant has submitted that the learned first appellate court has reversed the finding in connection with issue number 8. The suit was decreed.
This one.
The suit was decreed, the appeal was allowed. and consequently the plaintiff is the appellant before this court. He submits that the plaintiff sought declaration of right title interest and possession, right title and interest with respect to Schedule 1, 2 and 3 properties on the basis of registered sale deeds
Yes.
and also
And also for injunction. But.
and also
For injunction.
for injunction and also restoration of possession. The counsel submits that the plaintiff was restored forcibly, was dispossessed forcibly on 17/3/2007.
Yes.
He submits that the learned first appellate court, by reversing the finding, has not met with the reasons given by the learned tribunal.
Yes.
He has also submitted that there was no case from the side of the defendant regarding any exchange of property,
Without a doubt.
and the exchange was relied upon based on certain oral evidences placed on record.
Yes.
He has referred to substantial question of law number B. After hearing the counsel for the appellant, this appeal is admitted for final hearing on the following substantial question of law. Whether the findings of the learned first appellate court on issue number 8 is vitiated on account of not meeting the reasoning of the learned trial court, who had decreed the suit in favor of the plaintiff, holding that the sale deeds, all the 3 sale deeds of the plaintiff were valid and were never challenged or set aside. Issue notice to the respondents,
So.
sole respondent, through registered post and through speed post and ordinary process, for which requisites be filed within the week. Let the records be called for from the concerned. Let this order be communicated through fax.
अभी रिसेंटली ऑर्डर 5 में कुछ अमेंडमेंट आया, गजट नोटिफिकेशन आया होगा।
अच्छा, रिसेंट है?
क्या स्पीड पोस्ट से? स्पीड पोस्ट से?
हाँ, वो रजिस्टर्ड पोस्ट तो हम कभी नहीं करते हैं।
नहीं, वो स्पीडी पोस्ट हो गया सब।
हाँ,
वो नोटिफिकेशन भी आ
वो
गया।
पोस्टल डिपार्टमेंट अब रजिस्टर्ड पोस्ट खत्म कर
गजट नोटिफिकेशन आ गया तो
हम तो जब से जज बने हैं स्पीड पोस्ट ही करते हैं।
हाँ,
कभी नहीं।
दोनों
ऑफिस टू ट्रैक स्पीड पोस्ट। डेट 19 जनवरी।
कितना दिन तक?
Item 27, second appeal 132 of 2022.
where plaintiff
Judgment of reversal.
judgment of divorce. Partition suit was filed for partition of plot number 290.
Plot number
290.
29.
290. 290. It was self-acquired property of one Gopal Shah, the father of the appellants, and father-in-law of the defendant number 27.
Father of appellant and father-in-law.
Defendant number 27. And others are also there, but they were also defendant. They are the parties. They are the common descendants of Gopal. So far as
Just a minute. The learned counsel for the appellant has submitted that the matter arises out of a partition suit, which was decreed by the learned trial court.
which was decreed, we had asked for 1/6 share. The court has
Just a
given
minute.
1/4 share.
Which was decreed by the learned trial court and was relating to partition of plot number 290.
2.
The learned trial court had allocated
1/4 share to the defendant number 27 also.
1/4 share to defendant number 27 and आपको
हमको भी 1/4 share.
and 1/4 share was allocated to the plaintiff. However, the plaintiff claimed that it was the self-acquired property of the plaintiff.
No, we were saying that everybody has right, and it is a self-acquired property of the father,
Okay, so it was the self-acquired property of the father of the plaintiff,
Gopal Shah.
Gopal
Shah.
Shah. He has further submitted that the plaintiff was a son of Gopal Shah
Yes.
and defendant number 27 was the
Daughter-in-law.
daughter-in-law.
Yes. And other two sons have also been granted 1/4.
And the other two sons of Gopal Shah
Yes.
and brothers of the plaintiff
Yes.
have also been allocated
1/4 share.
1/4 share
1/4.
in the suit property.
They were altogether about 3 sons.
That's right.
And one son has predeceased his father.
That's right.
Daughter-in-law was also granted 1/4 share. The learned appellate court had reversed the finding and had allocated the entire property to defendant number 27.
The learned first appellate court has reversed the finding and allocated the entire property to defendant number 27.
Yes.
On what ground?
On ground that we have brought certain Batwaranama which was executed during the lifetime of the father itself. As per the Batwaranama, 290 plot he has kept for himself, and in the Batwaranama it is written that after his death, it will be partitioned among 3 the sons only, because one son had predeceased and the right of maintenance was given to her. This is in the Batwaranama. But so far as the defendant number 27 is concerned, she had filed a written statement that this particular property was allocated to the predeceased son, and it was his exclusive property. He constructed everything. This was the nature of the dispute. But she did not mention any date or any Batwaranama. But during the trial, a Batwaranama was produced. That is D exhibit D/4. But that was discarded by the learned trial court and saying that no, it is inadmissible and a false document. Because the experts were also examined and on the basis of the evidence, the trial court had discarded it and had said no, one third, but not instead of 1/3 each. He granted 1/4 to each and every. Also allocated the share to the daughter-in-law.
The learned counsel submits that the defendant number 27 claimed to be the exclusive owner of the suit property plot number 290 on the basis of one Batwaranama, unregistered Batwaranama.
Unraman registered.
Unregistered
Unregistered.
Batwaranama, which was marked exhibit D/4, which was thoroughly discussed by the learned trial court
Which is not even in the
and
pleadings.
it was discarded. He submits that there was no such pleading in the written statement filed by defendant number 27 making any reference to any previous partition. Previous partition का भी pleading नहीं है?
इसमें इनका कोई वैसा इसका बटवारानामा का रेफरेंस
With reference to Batwaranama exhibit D/4. He submits that the learned first appellate court, by reversing the finding and allocating the entire suit property of plot number 290 to defendant number 27, has relied upon the alleged Batwaranama exhibit D/4.
Yes. The defendant number 27 has filed a counterclaim also regarding the other plots which are not the subject matter of the partition, T28 and 289. But both the courts have rejected the counterclaim.
The learned counsel has also submitted that defendant number 27 had also filed a counterclaim.
Yes.
With respect to which properties?
Which equal to entire property including 290. 290, she was saying that it is her exclusive, and other plots 328 and 289, which belongs to father Lord Gopal Shah. She claims that she had property, easier share in those properties also.
But the claiming that plot number 290 was her exclusive property and claimed share with respect to other properties.
Husband's exclusive.
Claiming that plot number 290 was her husband's exclusive property and claimed share in the other properties of the common ancestor.
Of Gopal Shah.
Other properties of Gopal Shah. The learned counsel has referred
But the
to,
counterclaim was rejected.
but the counterclaim was rejected by the learned trial court as well as by the learned first appellate court.
Yes.
अब substantial question of law बताइए.
But the first is, but the E I would like to place it. It is at page 15. Whether the learned appellate court seriously heard in law as it completely failed to consider D/4 Panchanama Batwaranama dated 26/62 has been forced by defendant number 27 to claim suit which has been rightly discarded by the learned trial court as being inadmissible evidence. And first, it is equally important whether the learned appellate court by passing improved judgment and decree seriously heard in law as it failed to take into account true purport of exhibit 1, Batwaranama dated 24/4/65, which shows that plot number 290, which is self-acquired property of Gopal Shah and was never partitioned during the lifetime, and after his death the parties remained in joint possession over the same, and there was unity of title and possession, and the plaintiff and the third party, first party, second party, and fourth party, all are entitled 1/4 each at 10%. Whether the finding of the learned appellate court that Mosman Lakshmi remained in exclusive possession of
Exhibit 1 was rejected by the learned first appellate court.
First appellate court had not considered it for. It exclusively considered for the exhibit D/4, which the learned trial court has said, after expert opinion that it is a false and inadmissible also. But not having a brief computer to read the finding of the
Just
trial.
a
Father has himself partitioned the property, and in the Batwaranama of 1965, he has said so.
The learned counsel has referred to the substantial question of law number A and E. and I submitted that Exhibit D/4 was completely discarded by the learned trial court, and Exhibit 1 was relied upon by the learned trial court, but the learned first appellate court misdirected itself by relying upon Exhibit D/4 and not considering Exhibit 1. It submits that the judgment passed by the learned first appellate court is perverse. Yet, after hearing the learned counsel for the appellant, this appeal is admitted for final hearing on the following substantial questions of law.
The finding of the learned.
Whether the learned first appellate court has erred in law by failing to take into consideration the true purport of Exhibit 1 within bracket Batwara Nama dated 23/4/1965, which showed that plot number 290 was self-acquired property of Gopal Shah and was never partitioned during his lifetime. B. Whether the learned first appellate court erred in law in relying upon Exhibit D/4 within bracket Panchnama Batwara Nama bracket close dated 26/3/1962 in order to allocate the entire suit property and the entire property of plot number 290 in favor of defendant number 27. Though Exhibit D/4 was completely discarded by the learned trial court by holding it to be forged and inadmissible in evidence, and the learned first appellate court has not met the reasons of the learned trial court. बस inadmissible in evidence तक लिखेंगे, ठीक है? Issue notice to the respondents for which requisites under ordinary process and speed post be filed within a period of 2 weeks. बहुत सारे हैं, 2 हफ्ता में हो जाएगा, 4 weeks ले लीजिए, within a period of 4 weeks. Call for the records from the concerned court. Pose this case on January 27. आपकी सारी बात को हम सही माने हैं, मतलब रिकॉर्ड से टैली करेगा ना? आप लोग अब इतने सीनियर हो गए तो हमको इतना वेरीफाई करने की जरूरत नहीं, और अल्टीमेटली जब मैटर फाइनल हियरिंग में आएगा तो अपने ही पता लग जाएगा, ठीक है ना? आई नो यू विल नॉट डू दैट.
Item 28, Second Bill 159 of 2022.
Yes, ma'am.
Both the judgments are concurrent finals. In this title eviction suit,
You are the
the plaintiff in the suit, finals in the title eviction suit.
landlord.
These finals, he's actually the survived finals. He has survived those rights finals. So on the basis
Survived of a temple.
yes, finals. temple of a lady.
So why the courts have
Eviction
this?
suit.
Why?
They have not considered anything about the Shivayat manuals. Even the defendant in the written statement, they have accepted that I am the ancestor and I have
You
inherited
see,
this Shivayat
the
rights.
point is, the relationship of landlord and tenant has been proved or not. Not the title. We are not on title dispute.
Yes, my lord.
Is there any rent receipt?
Yes, my lord. It has exhibit 1 by 8. Without objection, it has been.
That is the only rent receipt.
My lord, it's a series of rent receipts.
Okay.
That is there, my lord.
Where is
And
that finding?
my lord, it is.
The plaintiff has brought on record by exhibiting some not proved document. What do you mean not proved?
Alicia, we have filed it and only the written statement has been filed by them. And they have not even raised objections to these series of rent receipts, 1 by 8. My lord, the findings start from page 71. Of the title eviction suit.
What is substituted plaintiff? Who died?
The main person, he died, my lord. And his son is substituted.
What does the court mean by saying that the plaintiff PW1 has brought on record by exhibiting not proved documents?
Although there is no objection also, but still it states that it has not been proved.
What does the court mean by saying that not proved? When it has been marked exhibit without objection? And what further proof they were looking for?
And issue it has been stated that
As it is a landlord-tenant relationship with the summary proceeding.
and in the written statement they have also accepted the fact that they were paying one bhog seva of this bhog or this seva that amounts to a kind of rent on my issue.
They were paying what?
This bhog of the DT financial in page 26 of the main trial.
Let us see the case of the defendant.
Yes.
Let us see the case of the plaintiff and the defendant. You come to page number 2 of the trial court judgment. The plaintiff, as per the case.
The plaintiff's case as per plain dated 10/2/2014 is that the plaintiff is the owner and landlord of some pakka rooms in plot number 679, 672 and 673 along with other plots of land of Mosa Papuria, number 76 district Papur under Jamavali number 110, and that the aforesaid plots of land total area being 13 bigha and 5 kattha 12 rows of land stand recorded in the name of Ram Nihara Das, son of Bhanu Das, as Sevayat of Narsingh Thakur in the last Ganser's settlement record. That the plaintiff has inherited the property in Sevayatship as the legal heir and successors of the recorded tenant. That the defendant had been a tenant under the plaintiff for a long time under an oral agreement at a monthly rent of 500 in one of the opposite rooms, which is the suit property. That on the basis of agreement, the room was handed over to the defendant. And on the basis of the terms and conditions of the agreement, the defendant had been paying monthly rent, sometimes through his son, Santosh Kumar Das.
Let's see the defendant's case, para number 3.
Para 3. that after summons on 28/7/2014, the defendant filed his written statement accepted on 15/9/2014. That same and except what are clearly and specifically admitted by the defendant in the written statement, he denies all above statements, contentions, and allegations made by of the plaintiff made by the plaintiff and defendant, puts the plaintiff to the strictest proof thereof. That the suit is not maintainable in fact and in law. That the suit is barred by the law of limitation by the principles of estoppel, waiver, and acquiescence. That the suit is devoid of merit, which is entirely based on conjecture and surmises, and the plaintiff has unscrupulously suppressed facts from the court, thereby making the suit likely to be dismissed outrightly. That the plaintiff has filed another suit wherein title suit number 3 of 2014 prior to filing of the present suit, whereby the plaintiff has inter alia prayed for declaration of his right title interest and for confirmation of the possession of the suit lands mentioned in the schedule of title suit number 3 of 2014, including plot number 669 over which the suit property of the incident suit is situated. And unless this said title suit is decided on merit, the present eviction suit is fit to be stayed under section 10 of the Code of Civil Procedure. That the plaintiff does not fall within the definition of owner landlord as defined under 2F of the Jharkhand Building Lease, Rental, Eviction and Control Act of 2000, thereby making the present suit non-net and non-maintainable in the eye of law. That the statements in para number 1 of the plaintiff are false and baseless and as such are vehemently denied by the defendant. That the defendant likes to assert in context that the properties including plot number 672, 669 and 673 and temples of the deity Narsingh Thakur is situated in Mosa Kapuria under Jababandi number 110. Place Kapuria, District Kapur, which is recorded in the name of deity Narsingh Thakur, and one Ram Mihara Das, who is a Sivayat and ancestor of the plaintiff, and was appointed as such by the royal family of Maheshwar, whose role was confined to that of a caretaker, worship management, etc. of the deity and temple, and the properties of the deity at no point of time, neither the ancestors of the plaintiff nor the plaintiff were owners of the property and temples of the deity in Jamabandi number 110 of Mosa Kapuria, and were as well never competent persons to act as landlord for and on behalf of the deity in the eye of law. That the statements of para 2 and 3 of plaintiff are denied by the defendant, being false distorted basis. It is stated that deity Lord Narsingh Thakur and
both are concurrent findings. So they say that for Bhog Rag they used to make monthly payment. And why and how and under what circumstances these exhibit 1 to 8 were which were marked without objection was discarded. I am not able to get that. Why is it so? No reason has been assigned. It has been marked exhibit.
it is several sections, several provisions have been stated in my leadership, like section 47.
There is it.
And leadership
Appellate court.
8 onwards.
Appellate court.
No, my leadership, the tribal actually para 10 and 11.
Okay.
And in para 10, in the second page, my leadership, it is stated section 47 of Indian Evidence Act proves that opinion has no handwriting when relevant. And again, section 67 has also been quoted.
The witnesses were cross-examined because they did not
They have not reduced any evidence.
adduce any evidence, but the witnesses were cross-examined or not?
No, my leadership, they have just resolution?
Just a moment. Okay. Heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that the plaintiff claims to be the Shivaya of the temple, of the temple, of the temple, and the defendant was inducted as a tenant. She submits that the defendant filed written statement and denied the relationship of landlord and tenant, but at the same time, the defendant stated that whatever monthly payment was being paid by the defendant to the plaintiff was for bhog rag of the deity and not as house rent. And it was being paid in lump sum for months together and nothing was lying due till the month of September 2013 for the suit property. The learned counsel submits that the rent receipts exhibit 1 to 1 by 8 were marked without objection and both the courts have, the learned trial court has discarded these documents by saying that the same was not duly proved. The learned counsel submits that the sole witness on behalf of the plaintiff had identified the signature, right? Identified the signature, and he was substituted after the death of the plaintiff. He submits that the rent receipts were also duly proved, and it stood admitted in the written statement that monthly payments was being made for the plaintiff used to receive monthly payments were required to be paid. She submits that the courts have the learned trial court dismissed the suit and the learned first appellate court has dismissed the appeal without considering the fact that without considering the written statement and the exhibit 1 to 1 by 8 which was duly proved, it was enough to hold that there was landlord-tenant relationship between the parties. She submits that there was no scope for the learned court to enter into the title dispute. They have entered into your title dispute also. Title dispute.
Statement and other title suit was pending.
Title dispute in connection with the plaintiff as one title suit seeking declaration of title by the plaintiff was pending. She submits that the judgments are perverse and substantial question of law we framed. Which substantial question of law are you referring? E. E should be sufficient. Should have been evidence of the plaintiff, particularly only exhibit 1 to 1/8 should be sufficient.
That's the only thing. And G also, but it's too long.
What was the amendment?
It has been mentioned in the plate 3 plot numbers and other plots, but the specific plot number 679 was mentioned in the earlier it was just mentioned and other plots mentioned.
She has referred to the substantial question of law as suggested in the memo of opinion.
He also mentioned, because they have also not denied that the plaintiff was from the same lineage and he had become the Sevayat. So he inherited this right.
Sorry. What?
In the written statement, they have
No, which substantial question?
A mentioned.
There is no doubt. If once it is a Shevayat, then Shevayat is otherwise an ineligible right. Isn't it? And that can be decided in a title suit, but not in a landlord-tenant relationship. So I think this E should be sufficient. After hearing the learned counsel for the appellant, this appeal is admitted for final hearing on the following substantial question of law. Whether the judgment and decree passed by the learned courts is perverse on account of rejection of the evidence of the plaintiffs in the facts of the case, particularly exhibit 1 to 1/8. Correct? In the facts of the case and in the light of the written statement filed by the defendant. How many defendants were there? One defendant?
One.
By the defendant. Okay. Facts of the case in the light of the written statement filed by the defendant. Okay. And exhibit 1 to 1/8, right? Issue notice to the respondent for which requisites under ordinary process and speed post be filed within a period of 1 week. Call for the records from the concerned court. Let this order be communicated through fax. Mr. Fax be posted immediately. Post this case on 27 January. Formal admission be over.
From date list for orders item 8, second appeal 374 of 2005.
Your order 41 वाले कितने cases रहेंगे? देखिए तो किसका है? Is anybody waiting for this case? Are you there for the next case? Are you there? Just a moment. एक order 41 का एक matter रह रहा है. Is there any
Item
counsel
29.
waiting for that case?
29.
Yes, are you there? What is it?
Against the counter findings.
Of eviction.
Eviction. The suit was
Who are
filed.
you?
I am the I am different.
Okay.
And no landlord tenant relation was established. I am not a tenant under the flat.
What is your right? What was your written statement?
My written
You were
statement.
claiming independent title.
No, I am
You
not.
are a trespasser.
I am in permissive possession of the original landlord.
Who is the original landlord?
Original landlord was Bhakti Vasini alias Bhakti Pradaya Dasi.
Bhukti,
Vasini.
you are the tenant under her.
No, I was caretaker.
Permissive possession.
Permissive possession.
Okay. Then she sold the property.
She never sold the property.
How does the plaintiff come into it?
Plaintiff, as per the plaintiff's case, that they have purchased the property, the successor of Bhakti Pradani sold the property to
By registered sale deed.
by registered sale deed in the year 1978 to
Yes.
and thereafter she sold that property to one Devki Devi in the year 1990. 92. First, in the year 1978,
Descendants of Bhukti
Bhakti Vasi,
Vasi.
alias Bhakti Pradayani Dasi.
Bhukti Vasini, the original owner,
Yes.
admitted owner of the suit.
Yes.
So
Died in the year
so
1978.
the plaintiff was claiming it through two sales.
Sale deeds.
Okay. Registered.
Registered sale deeds.
Okay.
As per the
Where
claim,
is the finding of landlord-tenant relationship?
there is no landlord.
Where is that finding? That is why you are here. No, there must be some finding.
And the title has been decided in the suit for eviction. The question of law issue has been framed as defendant are the plaintiffs absolute owner of the suit premises and defendant was allowed to live in the building as caretaker by Renuka Devi. That is the vendor of the present plaintiffs. Issue number 4 of the trial. In a suit for eviction, this has been
So
filed.
your case is that you never paid rent.
No.
So let us see the finding.
And without establishing
Where
landlord
is the
tenant
finding? Please
relation-
do not digress from the question. Where is the finding?
Yes.
There is a landlord-tenant relationship, and what is the basis of that finding?
Yes. First, trial court judgment, para 7, internal page 5, running page 20.
Para 7,
Para 7,
internal page 5.
5, running page 21. From the aforesaid assassin in the written statement and according to statements of defendants witnesses, it is clear that the defendants are not real owner of the property in question, rather they have been in permissive possession as caretaker. Now the question arises as per law that whether employee, servant and caretaker comes under the purview of tenant or not. Section 2H2 of the Building Act reads as follows: tenant means any person by whom or on whose account rent is payable for a building and includes a person who occupies a building as an employee of the landlord of such building, either on payment of rent or otherwise. from mere reading of the provision aforesaid, it is clear the servant, employee, and caretaker is a tenant by virtue of statute, and there is no doubt in my mind that defendants are also comes under the purview of provision aforesaid. This is the observation, and that has been affirmed by the first appellate court also. Para 7 of the appellate court judgment, running page 33.
Where is the finding that there is a landlord-tenant relationship?
It is not clear in the first appellate court judgment. In a general way, the judgment has been pronounced. There is nothing. Only one thing is there at running page 35, just after just 1, 2, 3, 4, 5, 7. Seventh line, para 8 above. In the present is the basic factor of denying the title of the plaintiff has not been averred in the evidence of any independent DW. Further, heavy burden was cast upon the DW to reward the relationship of landlord and tenant, and also prove the factor of how the defendant's right had retained over the period of time. Unfortunately, there is no evidence from the defendant's side to discharge the burden of proof in this respect. Further, it is choice of the plaintiffs, being the landlords, as to which property they want to live in, and no person other than them can have such a decision. This is the findings. Whereas the defendants are in possession in support of such contention, para 4, running page 13, to substantiate the pleading of the party, plaintiffs have adduced 10 witnesses on behalf of the plaintiff, cell deed number so and so.
Which is a substantial question of law.
Yes. DT, page number running to 9. Whether the first appellate court erred in law by not considering the facts and evidence on record that mere execution of sale deeds and the rent receipt does not create any title unless and until the purchaser is put into possession over the property covered by the sale deed. Whether concurrent findings of courts below, based on wrong assumption of fact, non-appreciation of pleadings and evidence on record giving rise of erroneous findings are sustainable. Whether in a suit for eviction, title can be decided of the plaintiff when there is specific denial of landlord-tenant relationships and the title of which are in question. And thereafter, E. Whether the long-standing permissive possession since 1956 by the father of the appellant, Sitaram Rawani, and thereafter by the appellant over Schedule A property of the suit at the instance of Bhakti Pradhani Dasi, the original owner, can be ousted. Whether the learned court below have considered that father of the appellant during his lifetime
I am
used to
asking
live.
you time and again, is there finding of any relationship of landlord and tenant between the parties? I could not get it, you just tell me.
There is no landlord-tenant
Be
relation.
very sure, आप थोड़ा पढ़िए ना. वही टाइटल डिस्प्यूट पे तो नहीं जा सकते, लेकिन रजिस्टर्ड सेल डीड है.
Registered sale.
टाइटल एंड पोजीशन आर टू डिफरेंट थिंग्स.
Yes.
राइट. रजिस्टर्ड सेल डीड है जिसको आप चैलेंज नहीं किया. Let's forget about the title. Is there any finding of landlord-tenant relationship between the parties?
7 except 2H2.
2H2. What is 2H2?
2H2 that has been mentioned in the judgment of the trial court judgment. That is definition.
Definition is not the finding.
But apart from this, there is nothing. Only this has been quoted. That since there is in the
You
statute.
just take your time, take 10 minutes. I will do some order spaces. I could not find it. You just tell me, I will record it. That there is no finding of landlord-tenant relationship between the parties.
Alright.
And you were claiming independent possession of the property.
Yes.
And you denied that. You just go through it. I will
Yes.
frame a substantial question of law, but
Yes.
you go through it. ये submission आपका गलत नहीं होना चाहिए ना.
Yes.
हाँ, थोड़ा 5-7 मिनट लगाइए.
अगर-
इत्मीनान से देखिए. There is, I don't think that there is any finding of landlord-tenant relationship between the parties. Okay?
Alright.
Just take your time, 5-10 minutes. Yes, Falcon.
Orders at 8, second April 374 of 2005.
Are you there for that? Of substitution of?
Substitution of legal here, okay. Respondent number 6B, 9 and 8. Substitution petition.
I see respondent number 9,
Due to inadvertence of loss.
17, and
17 for only because of this is and loss. I have given this supplementary. Supplementary affidavit on 29
तो किसका किसका आपका करना है बताइए.
6B, 9 and 8.
6B,
Naresh Mato. And 9 Keshav
और
Mato.
6B का लीगल ईयर्स कौन है?
6B का लिए I have stated the process.
Where?
Para 2.
Para 2 is respondent number 9.
Wrongly.
Respondent number 9 कौन है? नरेश यादव नहीं है.
नरेश यादव, नरेश महतो है. Respondent number 6A होना चाहिए. नरेश यादव की जगह पर महतो होना चाहिए. In this regard, I have filed your lawsuit. Supplementary affidavit.
ऐसा नहीं होगा. आप इसको ठीक से अमेंड करिए. आप इसका आईए को अमेंडमेंट करिए. ऐसा नहीं, इतना खिचड़ी नहीं बन सकता.
Then I withdraw.
विड्रॉ नहीं करना है, ऐसा नहीं करिए. विड्रॉ आप इस पर एक आईए फाइल करिए. इस आईए के अमेंडमेंट कीजिए. इसको अकॉर्डिंगली अमेंड कर देंगे. सप्लीमेंट्री एफिडेविट से हम इसको रेक्टिफाई नहीं कर सकते. ठीक है. IA number 10013 of 25. The learned counsel for the appellant has submitted that there has been certain inadvertent mistakes in the interrogatory application. He prays for some time to file an appropriate petition to rectify that. कब रख दें बताइए? बताइए 2005 का। आप कौन हैं? वन टू एंड
One plus legal representation. One has died. 1 to Roman 6. नहीं गुलाम मुस्तफा respondent. Legal heirs and successor of respondent number 1, 1 to 6.
गुलाम मुस्तफा।
7 and 8 का नहीं. They are not.
अब इसको रेक्टिफाई कर लीजिए। आप ऐसे नहीं कर सकते, आप उसको देखिए बहुत लिमिटेशन का कहानी शुरू हो जाता है, इसलिए ऐसा नहीं करें। आपने फाइल किया वन टाइमली फाइल किया, इसलिए ऐसा नहीं करें, इसीलिए आप उसको रेक्टिफाई कर लीजिए। इट्स अ वेरी स्मॉल थिंग। और सप्लीमेंट्री तो आपने ऑलरेडी फाइल कर ही दिया, आप उसमें यही बोलिएगा सप्लीमेंट्री फाइल किए थे बट अब अमेंडमेंट पिटीशन इज रिक्वायर्ड। पुराना केस में ये अबेटमेंट ये सब का बहुत इश्यूज होता है, इसको थोड़ा ध्यान से, ठीक है? कब रखें? 15 दिसंबर को रखें, पोस्ट ऑन 16 तारीख को सप्लीमेंट्री लिस्ट में डालें, ठीक है?
Item 9, second appeal 118 of 2010.
What is it?
Notices have been issued. It was served to other respondent matter, and it has come that respondent number 3-1, only Binda Mati Devi, has died. So I have received the instruction matter that only her name is required to be deleted because other affairs of Binda Mati Devi is already on record, and respondent number 13 and respondent number 15. And I will take this step a week. I have received all the information. Tomorrow I will try.
2A, 13 and 15 have expired. Right? It's a partition. So is it a partition?
It's a partition.
So ये respondent number 16 through brother who is respondent number 8, respondent number 11 through brother who is respondent number 9. इन लोगों का notice का accept कर लेंगे?
They are not contesting. Only respondent number 1 is contesting, that is Professor Shah. Others are formal respondents.
Respondent number 16, अच्छा 8 इसका insufficient address किया है, speed post का insufficient address है. Respondent number 10. Okay. SA number 118 of 2010. Respondent numbers 3 to 11 have already appeared by filing wakalatnama. Respondent number 16, 11, 12 and 14 have been served through their brother. The service is accepted as valid. Counsel for the respondent number 10 is present. Respondent number 2 with bracket A, 13 and 15 are reported dead. The learned counsel seeks it. कब करना?
रिसीव कर लिया सारे सर हम कल
I just request the matter is directed to be posted on next Thursday.
इसमें ऑर्डर किए थे
in supplementary list.
लास्ट ऑर्डर में आई ऑर्डर डेटेड 9/9/2025 Joseph has given the stay orders till 10th of November. उसमें था ऑर्डर में आया
तो आप लोग तो कुछ ऐसे सब्स्टिट्यूशन करते नहीं है,
हाँ
स्टे खाली चलिए आप।
नहीं हम लोग बोलिए हम आज रिसीव कर लिए दिस वीक में फाइल करेंगे
अगला फाइल करिए, अगला डेट में करिए।
Item 10,
एक्सटेंशन ऑफ स्टे भी फाइल करिए।
item 10, second April 49 of 2020.
Appealant, essay number 49 of 2020. Also for the petition, appellant is absent. As per office note dated 1/3/25, the respondent number 6 and 7 has been reported dead. So far as respondent number 1, 2, 3, 4, 5, 8, 9 and 10 are concerned, the notice has been received either by themselves or through their close relative. The notice upon them is accepted as validly served. The case was taken up on 4th of March 2025, on which the counsel for the appellant had submitted that he had not seen the records. However, from the records, it appears that the respondent numbers 6 and 7 were already reported as dead prior to order dated 4th of March 2025. Apparently, the proceeding as against the legal heirs and successors of respondent number 4 and 5 stands abated, has been abated. Respondent number 10 has entered appearance by filing wakalatnama. What I asked? The consequence of abatement in connection with deceased respondent number 6 and 7 will be considered at the time of final hearing of this case. अब तो कोई बचा नहीं मेरे ख्याल से 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 10 ही correspondent थे. Office is directed to place this case under appropriate heading on 15th of December. The records have already been received. आपने देख लिया?
Also, case item 29.
Not a single person.
Essay number 183 of 2022. The counsel for the appellant is present. The counsel for the appellant has submitted that the matter arises out of eviction relating to landlord-tenant relationship. He submits that the defendant was claiming independent right to live in the building as caretaker and was having the status of and was in permissive possession of the original owner of the property, namely Renuka Devi,
Since the year 1956.
since the year 1956. But the suit property and the plaintiff was claiming the suit property by virtue of registered sale deeds. He submits that there was no relationship of landlord and tenant between the parties. The learned courts have entered into title dispute with regard to the claim of title of the plaintiff, but has not recorded any finding of landlord-tenant relationship between the parties, and has passed the judgment of eviction. He submits that rent receipt was exhibited.
Exit.
Rent receipt of landlord tenant.
No.
No.
Of not landlord.
The learned counsel
Rent
submits
receipt.
that no rent receipt in connection with landlord-tenant relationship between the parties was exhibited before the court.
Rent receipt of municipal tax receipt
That's it.
filed by the defendants.
After hearing the learned counsel, he submits that a substantial question of law be framed and decided. After hearing the learned counsel for the appellant, this appeal is admitted for final hearing on the following substantial question of law. whether the learned courts were justified in evicting in passing a judgment of eviction against the plaintiff, against the appellant under the provisions of BBC Act without recording any finding of landlord-tenant relationship between the parties. Correct?
And the title has been decided in a recent.
उससे कोई जरूरत ही नहीं है. जब रिलेशनशिप ही नहीं डिसाइड किया तो बात करता. Let notice be issued to the respondents for which requisites under ordinary process and speed post be filed within a period of 1 week from today. Let the records be called for from the concerned court.
Waiting for stay of the execution since already date of delivery of possession has also been issued.
The learned counsel has submitted that. At this, the learned counsel for the appellant has submitted that IA number 3970 of 24 has been filed, praying for stay of execution proceedings, being execution case number 14 of 23, in connection with title within bracket eviction bracket suit number 21 of 1996, wherein writ for delivery of possession has also been issued. Considering the reported submission, IA number 3970 of 2024, let notice be issued to the respondents in IA number 3974 of 2024 also. Put this case on 15th of January 2025. Till then, further proceedings in the opposite execution case till 15th of January shall be made state.
All right.
This order be communicated to fax records for such.